सर आपका माइक म्यूट पे है।
Now is it okay?
यस सर।
Yes, sir.
So we are going to study what is section 5 of Indian Limitation Act, and this section I told you deals with extension of prescribed period on sufficient cause. Whatever period is written in the Limitation Act, how that period can be extended on showing sufficient cause. This section 5 of Indian Limitation Act is applicable to appeals, applicable to applications, but not to fresh suits. Please remember, this section is not applicable to fresh suits, and this section is not applicable to execution proceedings filed under Order 21 of CPC. And this section is also not applicable to proceedings before tribunals. This you must know before you start actual drafting of
proceedings before
application under section 5 of Limitation Act. Now, if you are taking the help of section 5, then any appeal or application may be admitted after the prescribed period if the appellant or applicant satisfies the court that he had sufficient cause for not preferring the appeal or application within such time. And there are grounds for taking advantage of section 5. What is sufficient cause? You will have to show to the court as to why you could not do, why you could not move an application within time, why you could not file your appeal within time. And dear students, what is sufficient cause in one case may not be sufficient in another case. All depends upon the facts and circumstances of each case. You see, in case of ladies, the abortion may be a sufficient point, sufficient cause. Imprisonment, if I was confined in jail and I was to file appeal meanwhile, so my confinement in jail may be a sufficient cause. My illness may be sufficient cause. I met with an accident and could not file the appeal, may be a sufficient cause. I was confined to bed, I was not able to move, may be a sufficient cause. And the ground misleading order or practice or judgment of the High Court. This is also a ground for condonation of delay, that the High Court passed such a misleading order, misleading judgment, misleading order that I could not get the order properly. And there is an explanation attached to section 5, which says that appellant or applicant was misled by any order, practice or judgment of the High Court in ascertaining or computing the prescribed period may be a sufficient cause. So if you are misled by the order or practice of the court, you can claim benefit of section 5 of Indian Limitation Act. Dear students, this Limitation Act applies only to instituted civil cases and not to pending proceedings. Pending proceedings means when a preliminary decree is prepared and then final decree is prepared, then this Limitation Act is not applicable. Or plaint filed after returning it and it is again filed, then limitation will not apply to the second time. It will apply only on the first filing of your application or appeal. And this act is not applicable to writs and criminal matters also. Section 467 to 473 of CRPC deal with limitation of taking cognizance in criminal cases. But there is only one entry in the schedule of Limitation Act, entry number 131, which gives 90 days time for filing revision under CPC as well as CRPC. And dear students, you must know that this Limitation Act only extinguishes the judicial remedy and not the right. And its exception is section 27 of Indian Limitation Act itself. You see, once your remedy is barred by Limitation Act, extrajudicial remedies are also always open. You can settle the matter out of the court even if it is time barred. Then law of limitation, is based on two maxims. There are two Latin maxims. First one is inter res publici ut sit finish litium, meaning thereby that interest of the state or public requires that a period or limit should be placed to litigation, or in the interest of society as a whole, litigation must come to an end. And second maxim means that law assists vigilantly and not those who sleep over their rights or are careless about their rights. So the equation is that period of limitation which is fixed in the schedule plus all possible extensions is equal to prescribed period. See, period of limitation is fixed in the schedule attached to the Limitation Act, and prescribed period will be calculated after adding all extensions, and it will always be longer than the period of limitation fixed by the schedule. And dear students, this extension of time is discretionary and not as a matter of right. You cannot claim limitation as a matter of right. There is a leading case on it, Ramlal versus Reva Coalfields Limited. When the period of limitation has expired, the decree holder has obtained a benefit under law of limitation to treat the decree as beyond the challenge, and this legal right accrued to DH by lapse of time should not be lightly disturbed. This leading case says once the degree holder has accrued certain rights because of lapse of time. So once decree cannot be executed because of lapse of time, then DH gets this advantage, and this advantage giving is again at the discretion of the court. Then, dear students, it is a duty of the court, you will see in section 3 of Limitation Act, to dismiss the plaint. Even point of limitation is not raised in the WS. And this is absolute and mandatory even at appellate stage, because the application of Limitation Act is retrospective in operation, and it applies to those facts or cause of actions which accrued before the act came into force. For example, an ex parte decree was passed during period of old act of 1908 in December 1963, and application for setting it aside is filed when Limitation Act of 1963 came in operation on 1/1/64. So application would be governed by new act, but benefits of old law will continue to be available to the parties. Then, dear students, this period of limitation fixed by law cannot be extended or restricted by agreement of the parties. Section 23 of Indian Contract Act says that any contract which violates any law for the timing in force is void. So you cannot limit or extend the period of limitation fixed by law. As I told you in the beginning, that law of limitation is a negative remedy in its operation, depriving a person of a power that is right to file a suit which he possessed before. It applies only against the plaintiff. Why? Because law of limitation is procedural in nature. This section relating to acquisition or losing of right by prescription are substantive in nature. Thus, Limitation Act is procedural as well as substantive in nature, and filing of application under section 5 is not necessary for condonation of delay as per language of section 5. Now I told you that in section 5 you will have to show sufficient cause, and what is sufficient cause you will have to explain to the court. Rule number 1 is that party seeking the relief has to satisfy the court that he had sufficient cause for not preferring appeal or application within the prescribed time. Number 2, the explanation has to cover the entire period of delay. Third, a litigant should not be easily permitted to take away a right which has accrued to his adverse party by lapse of time. Fourth, the proof of sufficient cause is a condition precedent for the exercise of the discretionary jurisdiction. Only after this proof, court has to inquire whether in its discretion it should condone the delay or not. 5. Discretion vested in the court is a judicial discretion and it must be exercised to advance substantial justice. 6. No liberal view should be taken merely because defaulting party is a government. Yes, maybe. 7. The delay cannot be condoned when there are laches on the part of the litigant. 8. If there is negligence on the part of the advocate, it has to be seen whether the mistake was bona fide or was merely a device to cover ulterior purpose, such as laches on the part of the litigant. Number 9. Each and every day's delay is to be explained under Section 5 of Limitation Act. Now, this is the actual drafting before you. The application under Section 5 of Limitation Act 1963 for condonation of delay. First of all, you will draft the name of the court. You see, we are taking the old illustration of pending case between builder and the purchaser. So the name of the court may be same, or if you have filed the suit in any other court, then the name of court will change. So here in this illustration, which I have adopted, the name of the court is in the Court of District Judge Noida, District Gautam Buddha Nagar, UP, Civil Appeal number dash dash of 2017. A son of B, who was plaintiff, now he is appellant. X son of Y, who was defendant, is now respondent. And the center heading is application under Section 5 of Limitation Act 1963 for condonation of delay. The appellant named above most respectfully submit as under. Para 1, that the appellant plaintiff, see, plaintiff is appellant now, that the appellant plaintiff had filed his suit for specific performance of the contract before the learned lower court, and lower court was pleased to dismiss the original suit of plaintiff on 1st July 2017 on merits. See, suit was dismissed. All right. Para 2, that the plaintiff appellant applied for certified copy of the judgment and decree passed against the plaintiff appellant on 1st July 2017, and the said copies were delivered to the plaintiff appellant on 15th July 2017. You see, there is a copying department in each and every district court from where you can obtain certified copy of the orders and judgments. Para 3, that the plaintiff contacted his counsel and got the memorandum of appeal prepared. The counsel for appellant called him for signing the documents and filing of appeal on 30th July 2017. You see, case was dismissed on 1st July. You have a period of 30 days for filing appeal up to 31st July. Para 4, that on 30th July 2017, appellant was about to go to District Court Compound Noida, District Gautam Buddha Nagar, but his pregnant wife started bleeding due to premature abortion. See, this is he is explaining as to how he could not reach the court in time. Para 5, the wife of the appellant fell unconscious and she was taken to Fortis Hospital, Noida by the appellant after calling an ambulance. The doctors performed an immediate operation, but the life of the baby could not be saved. However, his wife was saved by the grace of God. The wife of appellant was released from hospital on 25th August 2017 after hospitalization of around 27 days. Para 6, the appellant somehow reached the office of his counsel, Shri ABC Advocate, on 26th August 2017 and requested him to file appeal against the order and judgment dated 1 July 2017 passed by the London lower court. The appellant signed all the documents as directed by his counsel and accordingly appeal along with an application under Section 5 of Limitation Act is filed today. Para 7, that the appellant has not committed any mistake intentionally in late filing of this appeal. He was prevented from filing this appeal before this honorable court because of reasons beyond his control. You see, I have highlighted reasons beyond his control on account of accidental abortion of his wife. The appellant was not in a position to move from hospital during the period 30th July 2017 to 25th August 2017, that is 27 days, on account of the illness of his wife. Para 8, that there is no other adult member in the family of the appellant who could have taken care of filing this appeal in time, since the appellant and his wife live away from their parents in connection with their services in Noida. The parents of the appellant and his wife are resident of Mumbai and are old and infirm persons. Para 9, that the appellant has shown sufficient cause for not filing this appeal before this honorable court within period of 30 days from the date of impugned order. Para 10, the medical certificates of Fortis Hospital Noida are filed herewith after entering them in a list of documents. Para next 11, that an affidavit of appellant in support of this application is also filed herewith. Para 12, if this application under section 5 of Limitation Act 1963 is not allowed and appeal is not allowed to be filed, the appellant will suffer irreparable loss and injury, which cannot be compensated in terms of money. It is therefore most respectfully prayed that this application under section 5 of Limitation Act may kindly be allowed, and delay in filing this appeal may kindly be condoned in the interest of justice, and appeal of the appellant may kindly be admitted and heard on merits. Appellant will put his signatures over there, and since this application is to be moved along with appeal through some counsel, so you are supposed to draft it through counsel ABC Advocate, Court Compound, Greater Noida, Gautam Buddha Nagar, and date of moving this application along with memorandum of appeal is 26 August 2017. So dear student, this is how you will explain the delay caused in filing appeal. And in this connection, you should note rule number 1 is that day of judgment and time utilized by the staff of the court in preparation of certified copies of the judgment and decree is to be excluded. You see, the order was passed on 1st July 2017. So 1st July to 15th July, time was taken in preparation of the certified copy of the decree. So that time will be excluded in view of section 12, clause 2 of Limitation Act. Then period of 27 days, 30th July to 25th August may be excluded and condoned under section 5 of Limitation Act because the ground shown is sufficient. Third, the time for filing appeal will start from 2nd July. First day is to be excluded. 2nd July. Limitation for filing appeal against judgment of lower court is 30 days. This you can see from Article 116 of the schedule attached to Limitation Act. So dear students, this is one illustration of drafting of an application under section 5 of Limitation Act. You may have second illustration before you also. You have to show sufficient ground again for condonation of delay. See, the name of the court is same. In the court of district judge, civil appeal is the same. Appellant and respondent are the same, but the story is different. The center heading is same. Application under section 5 of Limitation Act 1963 for condonation of delay. The appellant named above most respectfully submits as under. That appellant plaintiff filed a suit for specific performance of the contract before the learned lower court, and the lower court was pleased to dismiss the original suit of plaintiff on 1st July 2017. That the plaintiff appellant applied for certified copy of the judgment and decree passed against the plaintiff appellant on 16 July 2017. And these certified copies were delivered to plaintiff appellant on 25th July 2017. Para 3, that the plaintiff contacted his counsel and got the memorandum of appeal prepared. The counsel for appellant called him for signing the document and filing of appeal on 1st August 2017. That on 1st August 2017, appellant was going to district court compound Noida, Gautam Buddha Nagar by his motorbike. On the way, unfortunately, he met with an accident with a car. The appellant fell unconscious and was taken to Fortis Hospital, Noida by the members of the public. The hip bone of the appellant was broken and replaced by operation. The appellant was released from hospital on 1st October 2017 after 2 months. The appellant somehow reached the office of his counsel, ABC Advocate, on 1st October and requested him to file appeal against order and judgment dated 1st July 2017, passed by the learned lower court. The appellant signed all the documents as directed by his counsel and accordingly appeal along with application under section 5 of Limitation Act is being filed today. Para 7, that appellant has not committed any mistake intentionally in late filing of this appeal. He was prevented from filing this appeal before this honorable court because of reasons beyond his control on account of accident. The appellant was not in a position to move during the period with effect from 1st August to 1st October 2017 on account of his own illness, and there is no other adult member in the family of the appellant who could have taken care of filing this appeal in time. Para 9, that the appellant has shown the sufficient cause for not filing this appeal before this honorable court within the period of 30 days from the date of impugned order. Para 10, that the medical certificates of Fortis Hospital, Noida are filed herewith after entering them in a list of documents. That an affidavit of appellant in support of this application is also filed herewith. Para 12 says that if this application under section 5 of Limitation Act 1963 is not allowed and appeal is not allowed to be filed, the appellant will suffer irreparable loss and injury which cannot be compensated in terms of money. Now the prayer clause, it is therefore most respectfully prayed that this application under section 5 of Limitation Act may kindly be allowed and delay in filing this appeal may kindly be condoned in the interest of justice, and appeal of appellant may kindly be heard on merits. Appellant will put his signatures there through counsel ABC Advocate of Greater Noida, Gautam Buddha Nagar. Date of filing this application is 1st October 2017. Again, note down, dear students, that the day of judgment and the time utilized by the staff of the court in preparation of certified copies of the judgment and decree from 16 July 2017 to 25th July 2017 will be excluded from a total period of 30 days for filing appeal in view of section 12 clause 2 of Limitation Act, and then period of 2 months from 1st August to 1st October may be excluded and condoned under section 5 of Limitation Act on sufficient grounds being shown, and the time for filing appeal will start running from next day of the judgment, that is 2nd July 2017. And you know that limitation for filing appeal against judgment of the lower court is 30 days in accordance with article 116 of the schedule attached to Limitation Act. My dear students, why the time for filing appeal starts from next day of the judgment? Because sometimes say it is the judgment was to be delivered on 1st July 2017 and it was delivered at 4:30 p.m. in the evening. So that day is already lost. So period of limitation is to be calculated from the next date of passing of the judgment. So dear students, this is how we have drafted and understood the law relating to section 5 of Indian Limitation Act.